Hi, are you keeping well? Well, I hope so. Today, I decided to hold this conversation with you. Well, it's going to be kind of a monologue, isn't it? But just to check that you're keeping up with your learning. The topic for this week is commercial disputes, and I hope you've been able to do some background reading. So, if you looked into the recommended text, it's chapter 10. Have you found it? Have you read through it? If you haven't, please do, because I think the key ideas and concepts that you need to know are quite nicely laid out there. So what I'll be doing in this presentation is I'm just going to take you through some of the key concepts and practices that you have to be aware of as a forensic accountant when it comes to commercial disputes. Well, the main thing will be understanding what you need to do and what you'll be expected to do, and just really get on with the estimates or the calculations of economic damages or lost profits. So when we had our presentations in class, I think we had a very nice presentation by Ryan on commercial disputes, and he gave us some very nice case study examples. Well, overall, the key idea is that as a forensic accountant, you may be at the center stage of helping litigants resolve financial issues that have come up, usually when they have fallen out. Okay, so usually when there are disagreements about transactions and events that these entities would have been involved in. And this really knows no boundary, right? These disagreements may arise for various reasons. So, for example, we may be looking at breakdown in contractual relationships. So there may be an allegation of a breach of contract for which one party claims that they've lost money. Okay, it may be because somebody relied on the word of another in terms of taking them to be experts or professionals, and because of that, if there has been a letdown, if there has been allegations of non-performance, or if you like, substandard performance, when the expectations have not been met, one party may claim negligence, and because of the tort regulations, tort rules, that might empower or give the party that has suffered a loss the confidence of making a claim. So whatever the reason for the dispute, you may be called upon to either advise, right? So you may be the consultant trying to get the people to agree or settle, or you may actually be an expert witness who will be coming to court to help the trial of facts come up with the estimate of the profit that has been lost, or if you like, the economic damages. So that is the background, right? And this, as we said, can come up in various reasons. The one thing that I have to say now is that valuation or valuing businesses becomes very intricately intertwined with commercial disputes. So what I mean is, for the resolution of most commercial disputes, there may be business valuation related tasks that would come up. But we will hold on to that for now, right? Our next lecture will be about business valuation. So I'll try very much not to bring up commercial disputes that would revolve around valuing a business. For now, we will look at other forms of economic damages that we may have to estimate. But the two main concepts that you have to remember when you come up to estimate economic damages or lost profit is you have to, first of all, try and understand if there has been causation. So we have to understand the concept of causation. Causation is all about us trying to, shall I say, proof? Try to bring evidence to the fore to support the idea that, but for an action, the loss may not have occurred. Okay, so there would only be the need to quantify the economic damage if we can support the idea that the action of one party or the inaction of one party led to the loss of income or the loss of profits or the causation of the economic damage. Do you get the idea? So the two concepts are causation and quantification. But before we quantify, which we normally tend to spend the bulk of our time on, we have to assess if there's been causation. And the two, if you like, ways to get your head around affirming causation is to check to see if there is an actual link, right? If one action or inaction led to the other. So that's what we mean by the but-for test. So before we quantify the loss, we will check to see if but for the action or the inaction, this loss would have occurred. Right? If that loss would have occurred anyway, then we will not go ahead and quantify because it's not being caused by the action or the inaction of the person or the entity who is in the wrong. Okay, so if we can prove that but for X and Y happening, this wouldn't have happened, then there is a case to be answered. Right? So then we can say that the loss occurred because of the action or the inaction. So let me summarize that. The first thing we do is we look at causation, and causation will be checked if we go through the but-for test, and we can prove that because of the action or the inaction, one party has suffered loss. But causation itself is not adequate. Right? We also have to look at any reasonable steps that the party who is suffering or suffered the loss took to mitigate for the damages. Right? So did they take any reasonable action to limit the loss? Right? It would not be acceptable if this party who has or is suffering the loss just continued as if nothing had happened and thereby exacerbated or increased the extent of the loss. Right? The court or any reasonable person would expect that even if the loss was occasioned by the action or the inaction of the other party, the party who is suffering the loss was reasonable in trying to limit the damage. So mitigation will have to be also considered. Okay, so what have we said so far? There are various reasons why commercial disputes might arise. We come onto the scene as forensic accountants to help resolve the issues and usually to quantify the losses or the damages. Before we do that, we have to ascertain whether there was causation, and we also have to check to see if reasonable steps have been taken to mitigate for these losses. If we are able to resolve these, then we go on and start thinking about how we will conduct our tests and usually come up with the figures to help resolve the issues. So I think I've said this before. You may be there, advising people out of court in your capacity as a consulting expert, or you may be testifying. And it doesn't matter. You still have to go about your responsibilities in a very professional way. So you prove causation and then you quantify the loss. You will have to go through your normal engagement procedures. I know we repeat this for each of these specific roles, don't we? So go through your client acceptance procedures. You have to understand the dimensions of the role, and ascertain that you're competent, you've got the resources to be able to deliver. And then you go about there and you design, you plan, you collect the relevant data, you analyze it, and you determine the size, or you determine the quantum, or you quantify the loss. And that would normally be written in your report. So report writing comes back. Lovely, isn't it? So we had that templates that we've been playing with. It's the same idea, right? You have to give the background, you have to describe the processes that you've gone through, the analysis, and then you produce your opinion. And of course, that will be supported usually by appendices where you show the very details. All right, so if you're able to prove, I say prove cautiously, if you're able to ascertain causation and you're on to the task of economic damages, then there are many ways that you could do this. You will have to be able to use the most reasonable method of calculating the economic damage. And you can see here that we're trying to use some of our very fundamental accounting concepts. The idea that there is lost profit suggests that we are looking at what if analysis, right? So if this loss had not occurred, how much would the other party have made? Okay, so you're kind of trying to look at restoration, right? You're trying to restore the party who suffered the loss to the situation they would have been in if the loss had not occurred, right? If the damage had not been caused. So you're looking at the but for injury kind of approach. So you have to pretend effectively as if the damage had not occurred, estimate what the profits would have been, and then compare that with the actual, and then see the difference. Okay, because we're talking about time in here, there may be time value adjustments. Okay, so money that would have been made over 5 years cannot just be lumped together, right? You have to look at the time value of money, and therefore you have to make some time value adjustments in terms of discounting. Sometimes the courts would think about punitive, or if you like, compensatory damages. So these are additional sums that may be added to the direct losses. Right? But it's not casting black and white there. Whether there will be punitive damages depends on the circumstances. We will have to be a bit careful sometimes when we are calculating economic damages. And I picked this very famous American case. You can use this link to read a bit more about it. But the idea is sometimes the economic damage is not limited to just a lost profit. Okay, because sometimes the damage or the event that occurred has destroyed the earning capacity of the other party, the party suffering the loss. So for example, if there's an incident that has led to the demise, the total collapse of a business, then we may not just look at the lost income. We may be looking at a situation of the entire value of the business has been destroyed. It may be a section of an entity as well. So we may be talking about economic generating unit, right? Maybe a strategic business unit, and all that earning capacity has been eradicated. If you calculate the loss on the basis of profits that might be different from the loss in terms of the total value of the business. So if that happens, sometimes the courts would rather look at the higher of the two, which sometimes becomes the value of the business. Instead of just the profit that was lost. So this is an instance where valuing the business may be a better way of calculating the economic damages. But as I said, we would leave the concept of firm valuation to next week. Okay. For now, just remember that economic losses or lost profits interact sometimes with the valuation of the business. So what do you do otherwise? If you're just, limited to looking at the lost profits, then what you're looking at is you're looking at lost revenues and the costs that are relevant. Okay. So how much revenue did the business lose because of the damage or because of the event? Well, linked to that is also how much costs was avoided, isn't it? Okay, so we're talking about avoidable costs here. So you're looking at the incremental revenue, the additional revenue. Notice that I'm using some management accounting terms here. So the incremental or the additional revenue that was lost together with the additional relevant costs that were lost. Okay. So how do you do that? You may have to look at historical data. So look at some prior year performances. You may sometimes also look at benchmarks or average performance in the industry. You may, if you have reliable data, also look at the market share that the firm had before and after. Sometimes there are some very specific or unique contracts that the firm was going to rely on to generate income. And if the event has stopped it from performing or delivering the contracts, then we can see causation there. We can see that the actions or the inactions of the erring party robbed the firm of delivering these contracts. So that could be also relevant, or that could be taken into account. So what we're saying here is when you have the role, you may have to look at the specifics of the case, and you will have to look at various bits of data to come up with what's the most reasonable way of estimating the what if profit. And all that you do is you may have to run through all these techniques, come up with the estimates, and try and justify the one that is reasonable. And that is what the parties will be looking for, or if you like, that's what the courts will be hoping that you'll be able to help them to do. We may link this with criminal activity or ill-gotten wealth, but that will be for another day. Okay, so I've given you a quick illustration here. So let's look at historic data here. So we have some data on a firm. Let's assume, for example, that there's an event that happened in 2007. Let's say that's a non-performance or a breach of contract happened in 2007. And because of that, this firm is alleging that there's been an impact on its earnings. So it's going to bring a claim. So 2017, the breach occurred. We have some market data for the industry, and we have the firm's data. Okay. So what we're trying to do here is we're trying to think about how to estimate the lost revenue. What do you think? What can we do? We can calculate, if you can see here, we can calculate the market share. I think I've got some data here. So what I've done is I've just calculated the the market share of the firm. Oops. Get this to work properly, Charles. Right, so what we've done is in 2014, we've calculated the market share as 50 out of 500, which is 10%. We've done it for 15, done it for 16. Just make this bigger a bit. Yeah, maybe that helps. Right, so we can see that over the years, the company's market share was 10%, went up to 12, 14, and then it went down to 12 in 2017 when the alleged breach occurred. And then it started falling further in 2018. So it went down to 10% in 2018. And it's gone further down to 8% in 2019. So you can see that there is a downward trend. So what we're saying here is this firm might have a case to say that the breach indeed has caused economic damages in terms of lost revenue. Of course, we will have to ascertain the facts about what the contract related to and what is happening in the entire market. For example, it may be a general market trend, but it doesn't look like that. You can see if you look at the market sales, the market sales are going up, but unfortunately, our firm's proportion of that market is going down. And if it can be proven that this indeed is happening because of the breach, then we will have to probably look at the average, the average market share before that's what we are trying to do here. Right, so before the market share, we could try and look at what the market share would have been. Take the average there of the figures that would have been before, and then we look at the after, and then try and work out the difference. What you're trying to do here is you have to be very pragmatic and you have to be fair as well, because look at the claim here. You can see what our firm here is saying is that but for the event happening in 2017, they think that this would have been their market share. Well, again, you have to look at the facts of the case to check to see if these claims are too high, because before the loss they hadn't hit 15%, but you can see here that they are claiming that they would have had 15, 16, and I mean 17%. So there is that dispute there, and the facts in terms of how competitive they are, and in terms of what this would have really led them to achieve, would be considered to resolve the issue in terms of whether this is a reasonable claim to make. For example, we mentioned the idea that they may have secured exclusive contracts. So it could be that they were relying on the performance of this airing party to be able to meet some tender contracts that they had won. So if that's the case, then it is probably likely that these figures would have been reasonable. But what we're saying is it all depends on the facts. Certainly, we can see there probably has been an impact, and we have to look at the full facts to see if indeed, but for the breach, the market share would have been theirs. So I hope that gives you an idea. Well, these concepts also come up when you're looking at various claims that relate to intellectual property litigation. So if there's been infringement of somebody's patent or copyright or trade secrets and all that, then we will be looking at a but-for situation, right? And there may be ill-gotten wealth there. So if somebody infringed on another party's intellectual property and earned money, then they shouldn't keep that money. There might be a claim, and that claim will lead to various forms of economic loss estimates. Okay, so I think that probably gives you a fair idea, and I would leave it there. I will leave you with this activity, leave you to think about any 6 items of key information that you would require if you were involved in a loss profit estimation. For example, for a key supplier who has breached a contract. So if a key supplier breached a contract and that led to lost profits, what kinds of information would you need? Remember the example that we were looking at not long ago. What kinds of information would you need to be able to estimate the but-for profit? Or why don't you look at a competitor who has infringed on copyrights? Now, what kind of information would you be looking for if you were estimating the but-for profit or economic losses? So I would cover these in a seminar. I would end this up here by saying there are, of course, varied reasons why we may be called upon as forensic accountants to be involved in commercial disputes. We are there to check to see if there has been causation of a loss. We will look at the full facts. We will assess the situation. If we're competent and capable, have the resources, we will take it up. And in delivering our role, we will be quantifying the loss. And in quantifying the loss, we'll keep an eye on any mitigation that should have taken place. This would normally involve looking at a couple of years' performance, maybe historic, it may be in the future, which might lead to various time value adjustments. But in doing all that, we are trying to check to see, but for the injury, how much money would the party that has suffered the loss, how much money would they have made? So I hope this helps, and I'll see you in a seminar soon. All the best.